A big welcome to everyone joining our webinar today on virtual arbitrations in the UAE, which is jointly hosted by the CIArb Middle East branch and Beale & Company's Dubai office. I'm an associate, my name is Habib, and I'm an associate with Beale & Company's Dubai office, and I'm also on the CIArb Middle East branch committee. So a big welcome to everyone joining us today. It's exciting for us because this is our first webinar as the CIArb Middle East branch, and in the coming months we will be hosting various webinars discussing different points and different issues in arbitration and alternative dispute resolution. So make sure to watch this space. Today we have a fantastic panel of speakers who will share with us different perspectives and the different experiences in virtual arbitrations in the UAE. As you all know, this has become a very topical issue because of the situation and the circumstances we find ourselves in. Our discussion today will be moderated by Claire Miller. Claire is our managing partner in Beale & Company's Dubai office, and she also sits as an arbitrator. She comes highly recommended and highly ranked in Chambers Global and in the Legal 500 and Who's Who Legal. She also has over 17 years dispute resolution experience. So without a doubt, today's panel is in very capable hands. And with that, I hand over to you, Claire.
Thank you very much, Sada, and thank you very much to everyone for joining us today. It's quite a different world we live in compared to 3 or 4 months ago. And for those of us in the arbitration community, as practitioners, as arbitrators, experts, or even parties to the arbitration, we're having to think of new ways of doing business, which of course gives rise to this whole concept of virtual arbitrations. And what we're going to look at this afternoon is virtual arbitrations here in the UAE and some of the issues that that concept gives rise to. We are very lucky with our speakers this afternoon. We have 5 contributors who are some of the leading sort of practitioners in this field. And reflecting the fact that both the UAE and arbitration is very international, our 5 speakers are right now based in 4 different countries. So I'm going to very quickly introduce you to them all, and I'm going to sort of start with the most geographically distant to the UAE and then work our way in. So the first person I'd like to introduce you to is Lynne McCafferty, Queen's Counsel. Lynne is a construction barrister who practices from Four Pump Court in London and the United Kingdom. Lynne is very highly regarded, and we're lucky here at Beale & Co. that we've been able to work quite closely with her on a number of projects. Lynne is particularly recognised by Legal 500 EMEA as one of the leading practitioners in the Middle East. Moving, I think, east, our next speaker is Elena Verronovich. Olena is a case manager at the Dubai International Arbitration Centre. Elena is normally based here in Dubai. This afternoon she's joining us from the Ukraine. She is very well known of the arbitration community here in Dubai in the Middle East. We take a journey now, I think, southeast, if my geography is right, and I can introduce you to Professor Mohamed Abdul-Bahab. He is the founding partner of Zulficar and Partners in Egypt. He has a very impressive practice, both as an arbitration practitioner and as an arbitrator, and he's recognised as a leading authority in both these fields. Finally, we reach the UAE, and if I can introduce you to Dania Fahs, who I think we're having on Dania's screen at the moment, but don't worry, she's joined us. Dania is the Deputy Director at the ICC Arbitration and RDR Centre for the Middle East and North Africa office based in the UAE. As everyone knows, the ICC is probably one of the leading arbitration institutions in the world, and it's people like Dania that add to that reputation. And then finally, if I can introduce you to Mr. Ali Hashimi, who I think, Ali, you're just down the road from me here in Dubai. Ali is the managing partner of Global Advocates, and he is probably the most recognised and leading authority in the UAE, both as a lawyer and an arbitration practitioner, a legal expert on all things UAE law, and also as an arbitrator. So as you see, we've got quite the guests with us this afternoon, who no doubt have lots of interesting points to share with us. We have identified between the group 6 issues that we think are pertinent to start the discussion about virtual arbitrations. And I'm going to kick off with the first one, which is all to do about hearings, virtual arbitrations. And what we've done is we divided this topic into 2 points, which are what has been your recent experience with virtual arbitrations with hearings, and how have you seen that this can or has improved efficiency in arbitration? And there's a second point to this issue as well, which is a virtual hearing requires both parties to agree. What if a party who is seeking to disrupt the arbitration or is reluctant for good reason to agree to a virtual arbitration takes the position that must take place in the seat of arbitration, the physical seat, for example, in Dubai. And this cannot occur in a virtual arbitration where you have parties, the tribunal based in different parts of the world, and potentially the witnesses as well. We know this is yet to be tested, but what are some of the issues which flow from this, and what can a tribunal do in such a case? These are points I would like Lynne, Dania, Mohamed and Ali to address. And Lynne, perhaps I can hand over to you to address the first of those points.
Thank you very much, Claire, and everybody. It's very nice to join you all. In terms of virtual hearings, I've had hearings in a number of different jurisdictions and different formats now, both court and arbitration. But one thing I think has stood out in all of those is that there are some improvements in efficiency to take away from this remote working experience. And I think really that falls into 2 different areas. First of all, I've noticed that generally advocacy style has become clearer, more direct and more concise. I think as people understand that perhaps they have less opportunity for the sorts of grandstanding that you sometimes see in courtrooms, but also that the arbitrator or judge has to concentrate harder when you're all on screen than you do when you're in person. You have a more natural conversational dynamic. So I can see over these past few months that people have adapted their style to suit. I think the second area where there have been improvements in efficiency are in the use of electronic bundles. And I think this is a really huge thing that's going to stay with us after lockdown is finally over. I'm a big fan of electronic bundles, having spent 10 months in a particular arbitration where we had a fantastic product that's available in the UK, provided by Opus. I've seen much greater take-up and much better use of document management systems during this period of lockdown. I recently had a hearing in the DIFC court, an application a couple of weeks ago, and we used their caseline system, and it worked extremely well. And one thing I find is that I'm sure so many of us on this call today are used to working with dozens, if not hundreds, of hard copy bundles, and it's so much more efficient to take everybody in the court and the arbitration room remotely to a specific page at a touch of a button on an electronic bundle than it is everybody getting down file number 65 and turning to page 220. So I think that's something that people are realising they can work with documents electronically, and it does work really well. I think just one slight point to raise, that it's not so much about inefficiency in remote hearings, it's more about building in a little bit more time. And what I've found, both in terms of estimating the time that's required for hearings and also in management of hearings, is that some time has to be built in, both to deal with some technical issues, such as the we've had today with Dania's camera, but I'm very pleased to see that we can now see Dania. And secondly, also, I think everybody's finding this concept of screen fatigue. I think when you have a day-long hearing, or if you have a 3-week hearing, 2-week hearing, to concentrate in a screen for the same amount of time that you would concentrate in court is actually much more tiring. And so what we've been doing with hearings that we've been setting up, both pre-trial reviews and so on, is building in some breaks in the mornings and the afternoons, just to help everybody, but particularly the judge or the arbitrator, to concentrate. So those really are the 3 things that I've taken away from the remote working.
Thanks very much, Lynne. Some interesting thoughts coming out there. And the last points, I think, kind of lead into the administration of arbitrations and how that change and the different role the parties, the tribunal, and also the administrative centres might have in considering some of them, which is a handy point to hand over to you, Dania, and get your thoughts on this point. I think you're on mute. Still on mute, which I think shows some of the issues we might have with virtual arbitrations.
By the organizer.
Perfect.
Can you hear me now?
Yes, we can. Perfect. Go ahead.
Thank you. Well, thank you, Claire, for this invitation for ICT to join this roundtable around the virtualization we've been seeing in arbitration lately, with a focus on UAE. It's a pleasure to be with this such a distinguished panel and our friends today. To follow up on what just has been shared by Lynne, obviously virtualization has started well before COVID-19 and international arbitration, and this pandemic has accelerated this process. And we've seen that it has given the chance to practitioners to experience virtual hearings. It is true that digitalization was already there when regarding document management, regarding submissions. At ICC, we've been receiving electronic copies of submissions since some time now, along with the hard copies. What happened under COVID-19 is that no longer the hard copies were received, but the submissions continued smoothly in electronic copies. Any initiating documents were received by the ICC by email, and the notifications also were undertaken by email in coordination with the claimant. As far as document management is concerned, the use of data rooms has been there and is still there. What's new is, as I was mentioning, the conducting of virtual hearings, evidentiary virtual hearings. And we know that there is some reluctance from practitioners to hold virtual hearings for various grounds. And we will get the chance to dwell on these grounds later on during the roundtable. But practice, as it turned out, showed us that many of these grounds were demystified, actually. And from the feedback we had from practitioners and arbitrators, counsels also, many advantages, as Lynne was mentioning, played out during this virtual hearing. Return to focused advocacy, which was very much appreciated by the arbitrators. Obviously, many arbitrators were suffering from being swamped in demonstrative slides during hearings. There was this return to straight to the point, focused advocacy that the virtual setup actually incite us to do, having no other option. Also, other issues like what we used to call when experts were examined, the night shift coming in. This was also an opportunity for arbitrators to request an early submission of concurrent evidence and try to be more interventionist. So many advantages were highlighted by the arbitrators. Obviously, there are some downsides, and we will be touching on these during the roundtable. As far as ICC is concerned, we've been early on actually responsive in issuing to the practitioners a guidance note, the ICC guidance note on possible measures aimed at mitigating the effects of the COVID-19. This is a guidance note that has 2 main parts. The first part is actually to recall to the arbitrators and the counsels about the available already procedural tools out there that can help them in accelerating the arbitration proceedings. When we think of tools, procedural tools, we think of bifurcation, early determination of issues, considering dispositive issues like a contractual limitation. I mean, all these procedural tools are available and can be used to their best. The second part is more dedicated to the virtual hearings and a sort of some guidelines, a checklist for cyber protocols that Professor Mohamed also will be explaining, as he has been experimenting lately, and a checklist and template clauses for procedural orders. The key remains preparation. The arbitrator should be preparing with the counsel this checklist, ensure that the parties have the right connection, the right IT equipment, as this relates to the equality of arms in an arbitration proceeding.
Thank you, and it probably highlights the importance of the role that organisations, particularly like the ICC and the DIAC have in relation to lessons learned, because there will be a lot of lessons learned coming out of this, and I'm sure there'll be ways which we can develop and overcome some of the issues. And a lot of that is going to come from feedback from people like Mohamed, like Ali. And Mohamed, if I could pass over to you, you of course sit as both an arbitrator and are an arbitration practitioner. So it would be very helpful to hear your thoughts.
Thank you very much. It's a pleasure to join this panel, and thank you, Claire, and everyone for being part of this. Briefly so, I don't want to repeat what my esteemed colleagues Lynne and Dania have mentioned, so I concur with all what I've said. Let me share with you a few things. I think we need to realize the specificities of virtual hearings now, because what has happened is that some practitioners over the past few years have taken the voluntary decision to go completely electronic. I, for one, more than about 3 years ago, decided that it's impossible to travel with suitcases and bundles and everything, and partly to save the environment, you can work electronically. And so I've been working electronically for the past 3 years totally. So what COVID-19 has done is that it has pushed people into a forced efficiency mode. So even if you don't like it, there are no options, but you have to go paperless. And I think this is a reality. The point that the takeaway is that virtual hearings have been more demanding on counsel side than the arbitrator side. The reality, these are the people who are pleading the case. The arbitrators, of course, are studying, asking questions, responding, but at the end of the day, the load and the burden really is much on counsel in this respect. So with that in mind, I fully agree with what Dania has mentioned, and I think the right word is focused advocacy was a manifestation of this virtual environment. There has also been procedural choices about what to say on the procedural side and save time for the merits. There have been reduced sitting time for arbitrators during the day virtually, even though in some big cases we have noticed that the number of days have increased to compensate for the time zone differences. Imagine a case with one party from the US, the other from Japan, and the arbitrators all over. There is a minimum common denominator of hours that they can sit during the day. So this resulted in less sitting time, but sometimes more days of hearings. There have been more efficiency with the cross-examination, choice of lines of cross-examination, choosing which witnesses you would rather cross-examine or experts compared to others. So in that sense, it has a forced efficiency mode in a way. What do we do with a reluctant party? And I think reluctant party is a catch-all word, because not every party that opposes virtual hearings is acting inappropriately. There could be valid grounds to do so. I think what we've seen and what I've witnessed in cases personally I'm involved in is that tribunals have had three options. Either the parties agree, so be it, no problem, to have a virtual hearing, or the parties agree not to have a virtual hearing. And here we've seen something people don't speak about, which is sometimes tribunals have been pushing the parties to go virtual when they have both said they don't want to have a virtual hearing. And I've had this in a case, and I think the idea is that as arbitrators, it's a party-driven process. If parties do not wish to proceed virtually, both of them, there is little that the tribunal can and should do, because at the end of the day, there is a party autonomy element. Now, of course, the idea is not to keep the proceedings hanging there without a determination, but certainly common grounds could be found. And then there is a third trend that we've seen. These are hybrid hearings, where we have virtual openings, possibly, or closings, sometimes elements of virtual cross-examination of experts, and then attempt to find some days in the last quarter of 2020 or sometimes even 2021 to have a cross-examination of witnesses of fact or other aspects of the hearing that do not lend itself to the parties' preferences or appropriateness of the case to a virtual hearing. So it's not one size fits all, but institutions like the ICC have been putting a lot of effort to ensure that there is efficiency into the process. And I think this is what I call the arbitration snowpiercer in the middle of the winter. It has managed to keep things on track when courts have went offline and could not do much and there was lockdown. So this is an element that arbitration has brought, an element of continued pursuit of justice at times when it was difficult for courts to keep up with that. These are the immediate points. Now, of course, the tribunal needs to balance the idea of having a party who's objecting. I think now an objection without good reason would be very problematic. So you need to have good reasons. You need to look at the lex arbitri. You need to look at the applicable procedural rules to see whether they give the tribunal the authority to proceed virtually. One aspect is the UAE arbitration law, which was enacted in 2018, law number 6, expressly includes reference to video conferencing and use of electronic communications as a possibility. So I think a party objecting to a virtual hearing in the UAE will need to put forward a very good case to see why their rights would be jeopardized if a virtual hearing is to proceed. The immediate response is that with the available technology, it is likely that virtual hearings could present themselves as a viable option, but I'm sure that in the coming months, we will see more and more technological applications that cater for the needs of the parties and make even virtual hearings more preferred in some instances, let's say.
Thanks very much, Mohamed. That's very, very interesting. And of course, you know, you mentioned the courts there. The courts here in the UAE, I think, quite quickly managed to adopt the systems they needed to go virtually. And I'm sure there's lots we can learn from them. And Ali, that's probably a useful time to hand over to you to look at this issue, because of course, you know, you're in the courts, you're practicing in the courts as well as arbitration, and the courts here do play a supportive role under the you know, the federal law on arbitration, both in terms of enforcement and also interim measures.
Yes, thank you, you know, for everyone here, and I would like to start by thanking everyone for you know, inviting me for this webinar. I second what my colleagues have just said about arbitration, without getting into the, you know, details and repeating. Two things before I get to the point of the courts and how the courts are looking into it, is that you know, the use of virtual arbitration perhaps, or the technology was there, but it was limited to certain aspects of arbitration. Why? Because parties were used to conducting arbitration physically, to traveling, to coming, sitting, having proper hearings. And now it's the other way around, perhaps, you know, after it's been tested by the arbitrators and parties, and now it became maybe, or it would become soon the norm, that parties will be willing to take the virtual rather than physical. And in addition to what was mentioned about you know, time, swiftness, how it becomes efficient, cost is very important. Reducing cost, imagine how much it would have been, you know, it would cost traveling, getting teams from different parts of the world to come and sit in a proper hearing. So that's one thing perhaps that we can, you know, keep in mind. In terms of courts, I would say it's important for any arbitration to understand that there are courts that complement what they do, and in this kind of environment, having arbitrations done virtually, we know that now courts are taking things virtually. Dubai courts have, for example, and I'm here talking about the whole UAE courts, but Dubai courts, for example, is stopped maybe for a very short period of maybe 1 week or 10 days maximum, and then after that, all hearings were done virtually. Up to date, up to today, actually, the hearings are before courts are virtually. Submissions are made, parties attend, and it's going very well, very swift, and therefore it's the courts that are now embracing. Now that comes out of the whole idea that a few years ago, I would say a decade ago or more, the directive of Sheikh Mohamed in Dubai to change the whole idea of e-government and to embrace the whole idea of e-government. That was a visionary, decision, I would say, to take 10 years or more, to embrace. Courts were ready, not just courts, public prosecutions, notary. You go to the notary now by only virtual, and you have things done. How this is important for arbitrations, we know that parties may seek to go to courts to have interim measures, and that swiftness or ability to go to courts when it's available, it makes the arbitration and the proceeding in general easy. Decisions in the court now, especially in the interim measures, are very fast, and I can't describe how fast it is enough. I'll give just one example. For example, last week we had an application on Friday morning, and it was Friday afternoon that we had a decision from the court. It's very fast, and it's during even weekends. Otherwise, you would, in the normal course of things, you would need to wait days, I would say, go and meet the judge and explain and do. Today, it's just a matter of, a tip of your finger. This also leads to the idea of the enforcement. Enforcement today, if you have an arbitral award that you want to enforce, you don't need to anymore to wait that long. Arbitration law made it easier when it came in 2018 in terms of its process, but now to have it as well virtual makes it easier, for all parties.
Thank you very much. And that's a really interesting point, because those of us, of course, who are practicing in arbitration here have seen, since the Federal Law of Arbitration has come in, just how quickly the courts have been dealing with either applications, interim measures, or challenges, enforcements, and it sounds like they're going to be able to deal with them even more quickly now, which is good. All right, well, let's move on to the second point we're going to discuss this afternoon, which is in relation to witness examination. A key risk in holding a virtual hearing potentially is witness tampering. We have all seen before, when we've been sitting in arbitration hearings, even reluctant witnesses who feel if they're not giving evidence on behalf of their employer, for example, they'd be asked at risk. And we wonder to what extent that might be compounded by the virtual hearings. And it would be very interesting to hear the panel's view on whether you've experienced this in any virtual hearings you've sat in the last few months. How can the arbitral tribunal circumvent this? We know that body language forms 55% of non-verbal communication, and therefore you're not seeing things such as someone obviously being very nervous, tapping their feet, scratching their face, or alternatively very calm and very measured, and part of that is what we judge witnesses' reliability on. So if I can put this out to Lynne, Dania, Ali and Mohamed again to address, and Lynne, we'll start with you again.
Thank you, Claire. I'm very pleased to say that I've not come across witness tampering myself in the last few months of working remotely, but it's certainly a great concern of my clients. One of the major things that they raise when they are expressing concern about how a full evidentiary hearing will work in these remote times. At a recent pre-hearing conference in advance of an arbitration hearing, we agreed a protocol between the parties to really, I think, assuaged the concerns of all the parties that were involved. And the protocol that we agreed involved, where technology allowed, having a second screen, a second video screen behind the witness. So as well as looking into the camera, they would have a screen behind them which would show the room and show that there was nobody in the room, nobody else in the room. And that was seen to be one way to deal with the concerns that people were raising about that. It has been suggested to me that it may be actually quite easy when you have everybody's face very close up on a screen to tell if somebody is taking instruction from somebody else or is reading an email on their screen and repeating it. And whilst we lose the advantage of having the sorts of non-verbal cues that you have in a hearing room with the body language and so on, we do have the advantage of seeing people's faces up close and being able to read the arbitrator's expressions perhaps, but also being able to read the witnesses' expressions. So although there are some disadvantages, I think those have been compensated in other areas. But I do think that a protocol agreed before an evidentiary hearing could be a way to reassure parties that steps are being taken to ensure that there's no foul play.
That's interesting, thank you, Lynne, particularly in relation to a protocol. I mean, Dania, is that something you can see the ICC getting involved in, about assisting or producing a protocol dealing with these sorts of points relating to witness evidence?
Absolutely, Claire. The ICC guidance note I just mentioned on possible measures to mitigate the impact of COVID-19 has an Annex 1 and 2 actually suggestion and a checklist that the parties with the arbitrator should make sure that they tick all the boxes. As I mentioned, preparation remains a key issue. Before holding the virtual hearing, a test should be run before. When there will be a witness testimony involved, obviously the counsel will have to prepare the witness. In some instances, a lay person can be involved, so it can be a peculiar environment for one to bring a testimony from the comfort of his kitchen or living room instead of a proper setup. So yes, there are some challenges that need to be overcome. Preparation will help. Protocols signed between the arbitrator and the counsel are very helpful tools in this respect. And the same also apply for expert examination. As far as witness tampering is concerned, and whether there would be someone coaching the witness in the room, and fears around these issues, as these were actually raised as objections to holding a virtual hearing, same as difficulty to read the witness. As Lynne just mentioned, technology actually demonstrated that there are some available tools. The 360-degree camera can have a full view of the room and make sure that no one is assisting the witness. As far as reading the witness is concerned, same again, the facial expression actually turned out to be way more visible on a screen. Even the twist of the eye can be seen by the arbitrator. So it's not the difficulty to read the witness, maybe it's over-reading the witness that can be involved here. And finally, I would say that one needs to take this with caution, reading the witness. To what extent it is useful to assess the credibility of the testimony, this is something that needs to be also taken with caution. Cultural differences can come to play, behavioral issues. People from different cultures react differently, we know, in their behavioral attitude. And I mean, this should be also taken with moderation, not to give huge importance to over-reading the witness. And arbitrators, with their knowledge and training, are familiar with these issues and are really self-aware of that more and more.
And that's probably a good time to actually hand over to our arbitrators, Mohamed and Ali, and get your views. Mohamed, should we start with you?
Yes, thank you. It's always much easier because my esteemed colleagues speak, and so I can speak less. And briefly, so I think with respect to witnesses, I would focus my comments briefly on the following. There is undoubtedly a degree of discomfort and skepticism. Partly this is driven and born out of the fact that this is a new practice to many. And so the less you know about it, the more skeptical you are. And so people are still in the phase of the trial and error in a way. But there are certain realities that we are seeing. It is no longer the case that procedural order number 1, that includes reference to witnesses and regulating hearing witnesses and everything, is sufficient. There is now in place a need for pre-hearing protocols dealing specifically with the virtual hearing of witnesses. And this involves a number of things, many of which have been referred to by my esteemed colleagues, but let me build on the following. For example, the idea of virtual backgrounds. I think for witnesses, it does not work. The tribunal and opposing counsel want to ensure that they have a full real view of the room where the witness is based. Now, there are other issues relating to connectivity. For example, a witness may not have available at hand good connection or reliable venue to connect from. It could be a home. We've had in one case, the witness was basically giving testimony from part of his own bedroom, and his child popped in. So you can expect that there are certain practices that people are having to cope with in a way. And this has brought out in another case the possibility of having the witness go, if that's not too distant, to the law firm or a law firm to have a room for the hearing from there. And this brings out a number of issues about whether anyone would be present, whether counsel from the other side would also be present. And given the physical distancing with COVID-19, it has not been ideal. But in one specific case, the witness, again, was looking up to the ceiling, every few questions having been asked. And at one point, the cross-examiner stopped and asked him, Mr. X, you constantly look to the ceiling. He told him, I'm thinking. So the tribunal then, for the comfort of everyone, asked the parties, please direct the camera and let us see what's happening in the ceiling. Now, if that was to happen in a normal hearing room, no one would take issue with it. But because you don't see, you're not in the same place where the witness is testifying, there is this degree of skepticism. And this builds on the point that Dania has mentioned regarding culture. Body language is important, and I think in the virtual as well as in the physical world. And I think the idea is that we need to, of course, observe and read body language, but reading too much into the body language may give you a wrong impression about the witness in a way. There are elements of culture, elements of background, elements of discomfort of being cross-examined, especially if it's your first case and you're alone. So in a way, there is this issue. I think what we've seen, and to build on what Lynne has mentioned, I'm yet to come across a case where we've had witness tampering during a cross-examination. But if virtual hearings are going to continue, I am sure that people would more or less have practices for and against this tampering in a way, because as the practice stabilizes, we will always see tools in favor and disfavoring this.
Thank you very much. Ali, is there anything you'd like to pick up on this topic?
Yes, I'll share experience of 3 different cases at 3 different time periods. The very first one was a few years ago, I would say more than 3 years. And this arbitration was seated in New York. So we were representing a party. So and there was the opposing party had a key witness, and that key witness was in Geneva. So we had everyone in the room there, but we had one witness and very key witness in somewhere else. So the arrangements were made. So as one of our teams travel to Geneva, be in the room, just to be sure that while this was online, virtual testimony, no one was in the room to assess the witness. Now, we know that this is not possible nowadays because travel is not possible. So the second experience was a week ago in a hearing, and I would have to say that it went very well. Witnesses were very clear. The testimony went very well. The cross-examination went very well. So there was no issue that one can say about it. And this is a good example of how can the conduct be good and swift. A third one was 2 months ago. It was in April. And in that arbitration, I was sitting as a co-arbitrator. I was in Dubai, chairman was in London, another party was in Australia, and a witness was, and again, another party was in Zurich, another witness was in Pakistan. And during the examination of this witness in Pakistan, this witness, the counsel has objected and said, I can see that this witness is looking in the room for kind of, his eyes is kind of everywhere, and there was a background sound. It's such as someone is trying to tell him the answer. Now, this was the objection raised by the counsel, and he was directed to focus on the answers, to give the answers, not to pay attention to anyone in the room. He was asked whether anyone was in the room. He said no, and therefore, the arbitration was conducted and continued. Now, that could be taken into consideration as perhaps possibility of a witness either trying to get assistance, or the whole idea of tampering with witness testimony. Yes, I think procedure need to be made, or let's say steps need to be made, whether it was in the institutions or by tribunals or by parties as well, parties agreement, and how to avoid such thing happening, in the hearings.
And that's a good point. I mean, we touched early on as well about, Mohamed was talking about the need for parties to be much more efficient, particularly if we have a much more shorter hearing day, because we have parties from, people from all over the world attending a hearing in different time zones. And we do know there can be a tendency for counsel to take what you call jury points, if you like, about a witness, looking around, looking for suggestions from other people. If your time is much shorter, you may now think about whether it's not worth your time actually making those points. Right, we're going to jump into the next issue, and this is an issue which is of interest particularly to our in-house counsel who are joining us this afternoon outside of the UAE, particularly in the UK, and it's in relation to Sharia law. And what, if anything, does one need to think about in terms of Sharia law when having a virtual hearing? And Elena Mohamed, if you could address this point, please.
Very quickly and clearly and bluntly, Sharia has nothing to do with virtual hearings, and there is nothing at all in Sharia that opposes this. And I'm saying this confidently because it is always the case. You find someone somewhere invoking Sharia principles as a scarecrow. In virtual hearings, my view is there's nothing.
Ali?
Yes, I think I fully agree with Dr. Mohamed, and adding one important point, an important principle under Sharia is permissibility is the rule. So everything is permissible unless there is a prohibition that one can find and particularly specify. So it's permissible so as there is no prohibition under Sharia. It's a mean to use the, and conduct such processes. Look at is how the courts are looking at it. The courts, we have, of course, Sharia courts in the UAE, for example, conducting their hearings virtually now.
Thank you, Ali. So there we are. We've heard it from the experts directly from the mouth. No issue with that at all. The next point we're going to look at is in relation to cybersecurity. The increasing use of technology is not without its risks. There was the hacking of the Permanent Court of Arbitration's website during a hearing of a sensitive maritime border dispute between China and the Philippines, where hackers placed malicious code on the PCA website, infecting the computers of diplomats, lawyers, and others who visited the website, and caused the PCA to temporarily take the website down. Lynne and Mohamed, I'm going to ask you to give your input on what can parties and a tribunal do to reduce exposure to such risks or attack, if they can, during hearings, particularly given the confidential nature of arbitrations, which is one of the cornerstones of it, why parties to commercial disputes sign up to it as the dispute resolution forum. And Lynne, perhaps if you could start off on that.
Yes, thank you, Claire. I think one thing to say about the experience of the last few months is that it's been good to see, with improved and increased use of these video conferencing platforms, the improvements made by a lot of the providers. So we've seen in a number of different platforms that have been software updates and so on to try to deal with the security issues that are being raised by people. But in terms of what the parties can do and arbitrators can do in advance of hearings, again, I would suggest that agreeing a clear protocol between the parties and the arbitrator in advance of a hearing, whether it's an evidentiary hearing or a procedural hearing, is going to be really key. And the sorts of things that need to be agreed are, first of all, that whoever is administering the call, so the arbitrator's clerk or whoever it may be, is provided with details of everybody who's going to join the call so that the administrator can see who is there, who should be there. And secondly, that there's agreement that everybody who's participating in the call adjusts the security settings in the platform they're using from the default settings to the highest security settings, so that everybody is forming as tight a security ring around the call as possible. And I think these sorts of protocols are going to be extremely important because, as you say, it's the whole point of arbitration is that it's confidential, and that's a very real concern for many clients in using remote facilities.
Thank you, all good points. Mohamed, what would you like to add to that?
Well, briefly again, I fully agree with Lynne, and let me briefly say the following. Your choice of words is very careful, Claire. You're trying to reduce a risk. It is impossible to dispense with the risk of cybersecurity breaches online. In fact, when you speak to engineers, the idea is if you want zero risk, don't connect to the internet. And in fact, you shouldn't have ever connected to the internet at any point in time. So what we're doing is that we're trying to, in a way, find the minimum risk, let's say, reduction processes or mechanisms. And I think there are many tools available and more will be as well. Then there are certain precautions, and tribunals need to be careful about this. Like, not only now is it password protected access to case documentation, hearings, but it goes beyond that, because you need to ensure that the participants in the process are not the weakest link. You may have an excellent person or a platform, but the person logging on may have easily been breached, which can bring about a breach. Pretty much, since we're still amidst the COVID-19, you could be completely within the four corners of your castle, not leaving home, but it takes simply someone visiting or someone just passing to carry the virus. So with this in mind, I think we need to be cautious, we need to be aware. I think there have been numerous efforts. One of the commended those efforts is the ECA New York Bar and the CPR protocol on cybersecurity, which is available to many. It also includes a checklist about what to consider. And I think what we need to do specifically with virtual hearings is, and using online platforms, is to acquaint ourselves with the minimum security requirements needed as advised by technical people. And as this goes on more and more, and we see more of the virtual arbitration hearings taking place, I am more than confident that in time, arbitral institutions globally will realize the need of having their in-house dedicated platform for cases they administer to ensure that there is least outsourced risk of cybersecurity breaches.
That is very interesting. And Elena, we haven't heard from you this afternoon. This is probably a good time to hand over to you and to get your and the DIAC's view on this. And the point I'd like you to talk about is what happens going forward. We've just had Mohamed talk about the idea that institutions prepare their own or use their own platforms to mitigate risk. Given the concerns and challenges that arise with virtual arbitrations, what sort of protocols can parties adopt to make the virtual hearing process more effective? It may be too early to say, but are you particularly seeing parties change their case management practices, for example, reduction of document request productions, and how do you see this impacting arbitrations going forward?
Thank you, Claire, for interesting question, and thank you everyone for sharing their valuable views on the current situation and the virtual hearings which are happening in the UAE. Of course, the current situation imposes certain restrictions and at the same time provides and creates certain possibilities that require parties to adjust their case management practice. However, what I may say that we didn't observe any essential deviations from the regular proceedings as such, which we used to experience before. To the contrary, the parties became even more vigilant and demanding towards the opposing parties toward the integrity of the entire process. While, of course, we notice, and I think this is something that is important for the Council to consider more carefully than before, the requirement and of the witness statements and the experts that they really wish to put forward. They need really to assess properly the purpose, what it serves. And we know that sometimes in the current circumstances, the parties prefer to reduce the number of witnesses, even in very complex cases, to those only who would really change the course of the arbitration, the course of the case, and could really be crucial for the final decision and for the final estimation of the tribunal. At the same time, of course, these times are challenging, but they create new opportunities, and the DIAC has currently engaged in creating the new digital case management system. And of course, nowadays it is the community is well aware of it, and some institutions even try to implement it to certain benefit of the parties, and this is where we also move to. We are planning also in light of the current situation. We are now considering the possibility of integrating a new platform, separate platform for audio and video hearings, which is very crucial nowadays. And also such things like electronic signature authentication services are also carefully considered if it is possible to be integrated into this digital system. So I think nowadays our main focus is on not denying this transition from tried and tested paper-based approach to digital one, but to making it as flawless and as smooth as possible, legally wise and technically wise.
And perhaps I'm being a bit cheeky asking you this as well, but it's anticipated that the new DIAC rules will be issued, at some point in the not too distant future. And, do you envisage at the moment that there might be adjustments to take account of the fact that there may be more virtual hearings going forward? Yeah, the DIAC rules are highly awaited by all community of the UAE, and of course, fortunately, I guess, also it may delay a bit, but fortunately, we are in the current, we experience current global change towards virtual environment, and of course, our rules now, we have a task force created some time ago, which extensively considering how the new rules, also they were, probably you already remember the draft, which was quite progressive, and but nowadays, of course, certain things has to be adjusted towards the future of virtual arbitration, and this is where we are now. Okay, good. Well, we look forward to seeing those. We're sort of entering the last 4 minutes of our time this afternoon, so we will jump to our final point. And this is a point we'd like Elena, perhaps you to address first, and then Ali, if we can finish the session with you. But it's about enforcement of an electronic award. Although the Federal Arbitration Law allows for virtual hearings, it requires an original copy of the final award to be submitted during ratification and enforcement award with the court. Given that institutions such as the DIAC temporarily stopped accepting hard copies of arbitral awards in compliance strictly with the COVID-19 protocols we had here, how likely is it that an unsuccessful party may challenge enforcement of the arbitral award because it's electronic? Is there anything that can be done from an institution's point of view? And Ali, perhaps a point for you to particularly address is, how do you see such challenges being considered by the court? Elena, perhaps you want to tackle that first before we hand over for a final word from Ali.
Yes, thank you, Claire. Of course, unfortunately, it is not uncommon in the arbitration that the losing party takes every possible opportunity of challenging the award, and regardless of the real validity of the grounds sometimes. And therefore, while the arbitrators should remain diligent and maintain the integrity of the process, I think that it is important that neither arbitrators nor the institution ponder to one party's unfounded wishes, and should always balance and find the most relevant solution in each particular case in order to obstruct any possible delay, and at the same time to mitigate the chances of setting the award aside. When we faced the complete lockdown in the UAE, we had to do something and follow, at the same time, we had to follow the governmental protocols to prevent ourselves and the community from this pandemic. But at the same time, we had to be vigilant towards the process itself, not to delay it and to act effectively. You know that our rules, they provide for the originals to be communicated to the parties. At the same time, the current arbitration law says that the arbitrators shall submit the award to the parties either in original or in copy. The wording of the provision itself doesn't give a clear view of its scope of application. One can say that it should prevail over the DIAC rules. However, my personal view is that its range is limited to ad hoc and administrative arbitrations, court-administered arbitrations. But in these circumstances, like it could be used to complement the rules to a certain extent, and this is what we take a little. And we didn't cease to accept the awards, and we continued to notify it electronically in accordance with this Article 44 of the Arbitration Law. At the same time, we requested the tribunals to provide us an urgent undertaking to submit at the future the originals once possible, because being mindful of requirements of UAE evidence law, I think it is Article 9, if I'm not mistaken, it says, as long as the originals are available, then it is sufficient to have a copy of the document unless it is contested, the accuracy of the document is contested by one of the parties. That is why once the circumstances allow, we start already receiving the original of the awards and communicating it to the parties. And I may say I was also surprised that during the complete lockdown, some parties were extremely cooperative and even either provided the tribunal with a complete agreement for the electronic copy. So because this is the safest side to prevent any annulment, but at the same time they even offered their own services for communicating the originals when it was within their powers. I will pass the mic to Mr. Al-Hashimi so that he could share it with us court practice maybe as well. Thank you.
Elena. Thank you, Elena. I think we need to start by making a distinction between, or at least defining what original means under these circumstances. Earlier, what I used to do, for example, if I'm traveling, and this is a real case, I was traveling to Singapore and I had to deliver an award, and I printed it, signed it, so there was an original copy, scanned it, and then sent it to the institution, to DIAC. And therefore there was a electronic copy that was communicated. I remember as well the discussion that we had with the case manager then about whether we need to send the original or we don't need to send the original because of the new arbitration law. We have today another, another thing that we have to take into consideration, which is a fully electronic document that has no original. And here you have the document has been drafted, signature is e-signature, so there is, and when you send it, that's the original. When you send it by email, that's the original that you have. You have not printed it, you have not signed it. So the original is electronic. And I think this needs to be taken into consideration by all stakeholders, I would say, whether courts, whether parties or institutions. In support of this, we have the arbitration law that allows for electronic, copies to be used. In support of that, we have the e-signature law in the UAE and in Dubai that was there a long time ago. It's been there since 2000, I believe 2006 or 2005. In support of that, there is the electronic evidence law that supports electronic documents and possibility of delivering such documents and accepting it by courts. Today, we have the same thing happening in courts. We are submitting our submissions to the courts in the normal hearings, in the hearings before courts and litigation, by way of sending this copy, or sorry, sending this original that is electronic, fully electronic. We don't sign it, it's electronic signature that is there. And I believe this is a reality today that we all need to accept, courts need to accept. How the courts will deal with challenges that would come is yet to be tested, and we have to wait and see.
Thank you very much. I think we can probably agree that, certainly from our experience in terms of when we have seen challenges brought under the new federal arbitration law, that they've dealt with it very sensibly. And we haven't always been on the right side of the decision in terms of who we're representing, but the decisions we have seen have been I think, fair in law. Thank you very much for your time this afternoon. If I can thank Lynne, Dania, Mohamed, Olena and Ali for joining us. I think the takeaway from this afternoon's session is there's a lot of goodwill in making this work. And with the sort of investment and feedback from organisations like the ICC and the DIAC, there's a lot of lessons learned we can take on board and develop how we take this forward. And obviously a lot more to talk about on this topic. As Farah said at the outset, there will be more sessions and we hope people do join us. But for now, if I can just say thank you very much and good afternoon.
Thank you very much.
Thank you, Claire.
Thank you very much.
Thank you. Thank you, Claire. Thank you. Thanks, everyone.
Thank you.